June 9, 1952. 10 a.m. Federal District Court, Southern District of New York, Manhattan. Ellsworth Bumpy Johnson stood in the defendant's area of courtroom 318 wearing a $2,000 charcoal suit tailored on Fifth Avenue, a burgundy silk tie, and Italian leather shoes polished to a mirror finish, facing federal judge Theodore Caldwell for his sentencing hearing 3 weeks after a jury had convicted him on 2 counts of conspiracy to distribute heroin. Johnson, who was 46 years old and who had been involved in organized crime for 30 years, and who had spent the past 6 years building the most sophisticated criminal network in Harlem's history, understood that today's hearing would determine whether he spent the next decade or the next 2 decades in federal prison. The jury verdict had not surprised him. The criminal justice system in 1952 was not designed to acquit powerful Negro defendants charged with drug trafficking, regardless of how questionable the evidence or how corrupt the investigating detective. But sentencing offered a final opportunity to fight back. Not for freedom, but for dignity and for revenge against those who had orchestrated his conviction through manufactured evidence and racial prejudice. Judge Theodore Caldwell, who was 62 years old and who had been appointed to the federal bench in 1947 by President Truman, and who had developed a reputation over the previous 5 years as one of the harshest sentencers in the Southern District when it came to Negro defendants charged with drug crimes, sat behind his elevated bench reviewing Johnson's presentence investigation report with an expression that combined professional detachment with barely concealed satisfaction. Caldwell had grown up in Virginia during an era when racial segregation was enforced by law and supported by violence, and although he had moved to New York in the 1920s to attend Columbia Law School and had built a successful legal career that eventually led to his judicial appointment, his attitudes about race had not evolved significantly beyond the assumptions he had learned as a young man in the South. He believed that Negro criminals represented a particularly dangerous threat to social order because they challenged white authority in ways that white criminals did not, and he considered it his judicial responsibility to impose sentences that would send clear messages about the consequences of such challenges. The prosecution, represented by Assistant United States Attorney Richard Morrison, had recommended a sentence of 15 years in federal prison based on the heroin quantities alleged in the indictment, Johnson's prior criminal record, and the federal sentencing standards applicable to drug conspiracy convictions in 1952. Morrison explained to the court that while conspiracy to distribute heroin was a serious federal offense that justified substantial incarceration, 15 years represented an appropriate balance between punishment and proportionality, given that this was Johnson's first conviction for heroin trafficking and that no deaths or serious injuries had resulted from his alleged distribution network. The recommendation carried weight because Morrison had successfully prosecuted the case, and because federal judges in 1952 typically deferred to prosecutorial sentencing suggestions unless there were compelling reasons to deviate. But William Consular Johnson's attorney, who had spent the 3 weeks since the verdict conducting an investigation that had nothing to do with appealing the conviction and everything to do with gathering information about Judge Theodore Caldwell, himself stood and requested permission to present mitigating evidence before the court-imposed sentence. Consular, who was 33 years old and who had already established himself as one of New York's most skilled criminal defense attorneys, through his willingness to represent unpopular clients and his strategic thinking that went beyond conventional legal arguments, explained that the defense had information relevant to the court's sentencing determination that addressed not only Johnson's character and circumstances, but also the broader context in which this case had been prosecuted and was now being sentenced. Judge Caldwell, who appeared annoyed by what he assumed would be another predictable plea for leniency based on Johnson's supposed charitable work in Harlem or his responsibilities to his family, granted Consular permission to proceed, but warned him not to waste the court's time with irrelevant testimony. Consular's first witness was Professor David Rothman, a sociologist from Columbia University who had spent 2 years studying sentencing patterns in federal drug cases throughout the Southern District of New York. Rothman testified that he had analyzed sentencing data from 1947 to 1952, covering 378 federal drug conspiracy convictions, and had discovered striking racial disparities in the sentences imposed by different judges. According to Rothman's analysis, Negro defendants convicted of heroin conspiracy received sentences that were on average 43% longer than sentences imposed on white defendants convicted of similar offenses involving comparable drug quantities and criminal histories. More specifically, Judge Theodore Caldwell's sentencing pattern showed that he imposed sentences on Negro drug defendants that averaged 61% longer than the sentences he imposed on white defendants convicted of virtually identical charges. In cases where Caldwell had discretion to sentence above or below prosecutorial recommendations, he sentenced Negro defendants above the recommendation in 82% of cases, while sentencing white defendants above the recommendation in only 19% of cases. The courtroom, which had been relatively quiet during the opening procedural matters, became noticeably tense as Rothman presented his statistical findings. Morrison objected that sentencing statistics were irrelevant to Johnson's individual case, and that attempting to prove systematic racial bias in judicial sentencing was an inappropriate collateral attack on the integrity of the federal judiciary. But Kunstler argued that the statistics were relevant because they demonstrated a pattern of discriminatory sentencing that suggested Judge Caldwell could not impose a fair and impartial sentence in this case, and that Johnson had a constitutional right to sentencing free from racial prejudice even if the legal system in 1952 rarely acknowledged or remedied such prejudice. Judge Caldwell, whose face had flushed red during Rothman's testimony, overruled Morrison's objection but warned Kunstler that he was approaching contempt of court and that questioning a federal judge's impartiality was a serious matter that could have professional consequences. Kunstler's second witness was Marcus Henderson, a former associate of Johnson's, who had worked in his organization from 1946 to 1950 and who had been arrested on separate heroin charges in 1951, but had cooperated with federal prosecutors in exchange for a reduced sentence. Henderson testified that during his cooperation meetings with prosecutors and agents in 1951, he had been asked repeatedly about Johnson's heroin distribution network and had been told explicitly by agents that Johnson represented a priority target because he was a Negro crime boss who had too much power in Harlem and who needed to be removed regardless of whether the evidence against him was completely solid. According to Henderson, agents had discussed planting additional evidence to strengthen the case against Johnson if his own testimony proved insufficient, and had suggested that Henderson could embellish his account of Johnson's involvement in specific transactions without fear of perjury prosecution, because prosecutors would protect cooperative witnesses who help build cases against high-value targets. Morrison objected strenuously that Henderson's testimony was hearsay, that it constituted an improper attack on the integrity of federal law enforcement, and that Henderson was a convicted felon whose credibility was deeply suspect. But Kunstler noted that Henderson had been the prosecution's own witness during Johnson's trial, that his credibility had been vouched for by the government when it served their purposes, and that his testimony about prosecutorial and investigative misconduct was directly relevant to whether Johnson's conviction and sentencing were tainted by improper motivations, including racial animus. Judge Caldwell appeared increasingly uncomfortable as Henderson continued his testimony, and when Henderson stated that one agent had specifically mentioned that Judge Caldwell could be counted on to give Johnson a harsh sentence because Caldwell did unlike Negro defendants who thought they were above the law, the judge interrupted, and stated that the witness's allegations were inflammatory and unfounded, and that this line of testimony would not be permitted to continue. Kunstler's third witness was the most devastating. Theodore Morrison, no relation to prosecutor Richard Morrison, was a white businessman who had been convicted of heroin conspiracy in and sentenced by Judge Caldwell to 8 years in federal prison, despite the fact that his case had involved heroin quantities comparable to those alleged against Johnson, and despite the fact that Morrison had a more extensive prior criminal record, including 2 previous drug convictions. Theodore Morrison testified that during his sentencing hearing in 1949, Judge Caldwell had expressed sympathy for the difficult circumstances that had led him into drug trafficking, had noted that white men of otherwise good character sometimes made mistakes that did not reflect their fundamental nature, and had imposed a sentence below the prosecutorial recommendation because Caldwell believed that Morrison could be rehabilitated and returned to productive society. Morrison stated that while serving his sentence at the federal prison in Lewisburg, Pennsylvania, he had met dozens of Negro inmates who had been sentenced by Caldwell for similar drug offenses and who had received sentences ranging from 15 to 22 years, substantially longer than his own 8-year sentence. Despite comparable or less serious criminal conduct, Morrison objected that this testimony was irrelevant to Johnson's sentencing and that attempting to introduce evidence from other cases was an improper collateral attack on final judgments. But Kunstler argued that the testimony was directly relevant because it demonstrated Judge Caldwell's pattern of racially discriminatory sentencing, that it showed Caldwell imposed dramatically different sentences on white and Negro defendants for similar crimes, and that this pattern created a strong inference that any sentence Caldwell imposed on Johnson would be influenced by racial bias rather than by neutral application of federal sentencing standards. Judge Caldwell, who was now visibly angry and who had maintained his composure through most of the hearing, despite the increasingly uncomfortable testimony, finally interrupted Kunstler and stated that he had heard enough that these attacks on his judicial integrity were approaching, if not crossing the line into contempt, and that he would not tolerate further attempts to introduce irrelevant comparative sentencing data. But Kunstler was not finished. He pulled from his briefcase a document that he had obtained through contacts in New York's organized crime community, a document that would prove far more explosive than any statistical analysis or witness testimony. The document was a series of canceled checks obtained from a source Kunstler would not identify, showing payments totaling $12,000 made over the previous 2 years from an account controlled by Vito Giannone, the Italian mob boss who was currently engaged in a power struggle with Frank Costello for control of the Luciano crime family, and who had been working to eliminate Johnson's independence in Harlem by any means necessary, including supporting his prosecution on heroin charges. The checks were made payable to Theodore Caldwell's wife, Sarah Caldwell, and the memo lines on several checks indicated they were payments for unspecified consulting services. Kunstler explained to the court that Vito Genovese had a direct financial interest in seeing Johnson imprisoned for as long as possible, because Johnson's incarceration would allow Genovese to seize control of Harlem's drug trade without opposition from the one Negro crime boss powerful enough to resist Italian mob expansion. The courtroom erupted. Morrison jumped to his feet, demanding to know how defense counsel had obtained private financial documents that appeared to suggest criminal activity by a federal judge. Several spectators began talking loudly among themselves. Judge Caldwell, whose face had gone from red to pale in the span of seconds, demanded that Kunstler explain the source of these documents and the chain of custody that would authenticate them. Kunstler replied calmly that he had obtained the checks through entirely legal means, that they were authentic bank documents that could be verified through subpoena of the relevant financial institutions, and that their existence raised serious questions about whether Judge Caldwell could impose an impartial sentence on Johnson, given the apparent financial relationship between Caldwell's family and the organized crime figure who most wanted Johnson imprisoned. Kunstler noted that he was not accusing Judge Caldwell of any crime, that there might be innocent explanations for the payments, but that at minimum the appearance of impropriety was so substantial that Caldwell should recuse himself from sentencing and allow another judge to handle the matter without the cloud of potential bias. Judge Theodore Caldwell called a recess and ordered both attorneys into his chambers immediately. The recess lasted 47 minutes, during which time Johnson sat calmly in the defendant's area while spectators speculated about what was happening in the private meeting between the judge and the lawyers. When court reconvened, Judge Caldwell looked considerably older than he had appeared at the start of the hearing. He addressed the courtroom in a voice that was controlled but noticeably strained, stating that he had reviewed the documents presented by defense counsel, that he categorically denied any impropriety or bias in his judicial conduct, but that in the interests of avoiding any appearance of prejudice, he was reducing the sentence he had intended to impose from 20 years to 15 years in accordance with the government's recommendation. He stated that this modification was not an admission that defense counsel's allegations had merit, but rather a recognition that judicial sentencing should be beyond reproach, and that even unfounded accusations could create doubts that undermined public confidence in the federal judiciary. Kunstler, who understood that Caldwell's sudden willingness to impose the minimum recommended sentence rather than the much harsher sentence he had clearly intended, represented a significant victory. Even if Johnson would still spend 15 years in federal prison, made no comment about the modified sentence, but noted for the record that the defense maintained its position that Judge Caldwell should recuse himself entirely, and that the defense would be filing a motion for recusal and for a new sentencing hearing before a different judge. Johnson, standing to receive his sentence, showed no emotion as Caldwell pronounced judgment. 15 years in federal prison, eligibles for parole after serving 10 years. To be incarcerated at Alcatraz Federal Penitentiary in California, a facility specifically designated for the most dangerous and high-profile federal prisoners. The sentence was exactly what the prosecution had recommended, but it was substantially less than the 20 to 25-year sentence that Caldwell had intended to impose before Kunstler's presentation of evidence regarding racial bias and potential judicial corruption. The fallout from the sentencing hearing began immediately. The New York Times ran a front-page story the following day with the headline, "Federal Judge Accused of Racial Bias and Possible Corruption in Drug Case Sentencing." The story detailed Kunstler's presentation of statistical evidence showing racial disparities in Caldwell's sentencing patterns, Henderson's testimony about prosecutorial misconduct and targeted prosecution of Negro crime figures, and, most dramatically, the revelation of financial payments from organized crime figures to Caldwell's wife. The article noted that Caldwell had denied all impropriety but had reduced his intended sentence after the allegations were raised, and quoted legal experts who stated that even if no criminal conduct could be proven, the appearance of bias was sufficient to raise serious questions about Caldwell's fitness for the bench. Other newspapers picked up the story throughout the week, and within 10 days the controversy had generated enough attention that the chief judge of the Southern District announced that the court would conduct an internal review of Caldwell's recent sentencing decisions to determine whether any patterns of bias could be identified. Beto Hanavis, whose financial payments to Sarah Caldwell had been publicly exposed through Kunstler's courtroom presentation, immediately denied any improper relationship with the judge or his family, and claimed that the payments were legitimate consulting fees for real estate advice that Sarah, who had briefly worked as a real estate agent in the 1940s, had provided to business associates of G. But the explanation was transparently inadequate, and federal prosecutors who had not been involved in Johnson's case began quietly investigating whether the payments constituted attempted bribery of a federal official. The investigation ultimately produced no criminal charges, largely because prosecutors could not prove that Theodore Caldwell himself had knowledge of the payments to his wife, or that the payments were made with the specific intent of influencing his judicial decisions. But the investigation did uncover that Sarah Caldwell had received similar payments from other individuals connected to organized crime, and that these payments had coincided with cases in which Theodore Caldwell had imposed unusually favorable sentences on defendants connected to Italian mob families. Theodore Caldwell remained on the federal bench for another 18 months following Johnson's sentencing, but his reputation was permanently damaged. Attorneys began filing motions for recusal whenever Caldwell was assigned to their cases, arguing that his demonstrated pattern of racially biased sentencing and his apparent financial connections to organized crime figures made it impossible for him to preside impartially. The chief judge of the Southern District, increasingly concerned about the negative publicity surrounding Caldwell and the growing number of appellate reversals of his decisions based on allegations of bias, began assigning Caldwell only to civil cases and administrative matters rather than criminal trials. In November 1953, 17 months after Johnson's sentencing hearing, Caldwell announced his retirement from the bench, citing health reasons and a desire to spend more time with his family. He was 63 years old, and his departure from the judiciary was widely understood to be a forced resignation orchestrated by court administrators who wanted to remove him before his continued presence caused additional damage to the federal judiciary's reputation. For Bumpy Johnson, the sentencing hearing represented a Pyrrhic victory. He had not avoided prison. 15 years at Alcatraz was a devastating sentence that would remove him from Harlem during what should have been the peak years of his criminal career, and that would allow his rivals to seize control of operations he had spent 6 years building. But he had accomplished something that mattered almost as much as freedom. He had exposed Theodore Caldwell as a racist judge who imposed sentences on Negro defendants and who had financial connections to the very organized crime figures who wanted Johnson imprisoned. He had forced Caldwell to reduce his intended sentence from 20-plus years to 15 years through the threat of further exposure, and he had destroyed Caldwell's judicial career, ensuring that the judge who had presided over his conviction with obvious racial prejudice would spend the rest of his life remembered not as a respected federal jurist, but as a corrupt official who had been forced into retirement after being exposed in open court. The story of Johnson's sentencing hearing spread rapidly through Harlem and throughout New York's criminal underworld. It became another chapter in the legend of Bumpy Johnson, a story that demonstrated his intelligence, his strategic thinking, his willingness to fight back even when facing inevitable defeat, and his ability to destroy enemies even from a position of weakness. Negro Harlemites who heard the story understood its significance beyond the specific facts of Johnson's case. It proved that powerful white judges who appeared untouchable could be exposed and humiliated if someone was smart enough and determined enough to gather the right evidence and present it in the right way. It demonstrated that racial bias in criminal sentencing was not just a subjective feeling, but a documentable pattern that could be proven with statistics and witness testimony. And it showed that even when the system was rigged against Negro defendants, there were ways to fight back that went beyond traditional legal appeals, and that could achieve victories measured not in acquittals, but in the destruction of enemies' reputations and careers. From his cell in Alcatraz, where he arrived in August 1952 to begin serving his 15-year sentence. Johnson would later write to his wife, Mame, about the sentencing hearing and what it had accomplished. The letter, preserved in the Johnson family papers, reflected his understanding that exposing Caldwell had been almost as important as reducing his sentence. "They wanted to bury me for 20 or 25 years, he wrote. "They had a racist judge who was prepared to give me the maximum possible sentence because I am a Negro who had too much power in Harlem. But we gathered evidence that destroyed that judge's career and forced him to give me only 15 years instead of the 25 he wanted. I'm still in prison. I am still away from you and away from Harlem for at least 10 years before I am eligible for parole. But Judge Caldwell is also destroyed. His reputation is ruined. His career is over. Everyone knows he's a racist who took money from the mob. That won't get me out of here, but it means something. It means I didn't just accept what they did to me. It means I fought back with the weapons I had." The broader implications of Johnson's sentencing hearing extended beyond his personal case. The exposure of racial disparities in federal sentencing, documented through Professor Rothman's statistical analysis and through comparative testimony about white and Negro defendants receiving dramatically different sentences for similar crimes, contributed to growing awareness among civil rights organizations about systematic racism in the criminal justice system. The NAACP Legal Defense Fund cited the Johnson case in subsequent briefs, arguing that racial bias in sentencing violated constitutional guarantees of equal protection under law, while courts in the 1950s were not yet willing to overturn convictions or sentences based solely on statistical evidence of racial discrimination. The Johnson case helped establish the factual foundation for later legal challenges to discriminatory sentencing practices that would eventually result in reforms decades later. The revelation of financial connections between Judge Caldwell's family and organized crime figures also prompted reforms in judicial ethics, rules, and financial disclosure requirements. Prior to the Johnson case, federal judges were not required to disclose their spouse's income or financial relationships, and there were minimal oversight mechanisms to detect potential conflicts of interest arising from family members' business activities. Following the publicity surrounding Caldwell's forced retirement, the federal judiciary implemented new disclosure rules requiring judges to report significant financial transactions by immediate family members and to recuse themselves from cases involving parties who had business relationships with their families. These reforms, while modest by later standards, represented recognition that judicial integrity required not just avoiding direct bribes, but also maintaining distance from any financial entanglements that might create appearances of impropriety. Theodore Caldwell died in 1971 at age 81, 19 years after Johnson's sentencing hearing and 3 years after Johnson himself suffered a fatal heart attack at Wells Restaurant in Harlem. Caldwell's obituary in the New York Times, which was brief and appeared in the back pages rather than on the front page, where obituaries of prominent former federal judges typically ran, made no mention of the controversy that had ended his judicial career or the allegations of racial bias and financial corruption that had defined his final years on the bench. But among attorneys who practiced in federal court in New York during the 1950s, among Negro defendants who had appeared before Caldwell and received harsh sentences that seemed motivated by race rather than by the facts of their cases, and among people who remember the Johnson case, and what it revealed about systematic racism in the criminal justice system. Caldwell's name remained synonymous with judicial prejudice and the corruption of the bench. Bumpy Johnson served 11 years of his 15-year sentence before being released on parole in March 1963. When he returned to Harlem, he found a neighborhood transformed by the heroin epidemic that had exploded during his imprisonment and by the power vacuum created by his absence. But he also found that his reputation had grown during his incarceration, enhanced by stories like the sentencing hearing where he had destroyed Caldwell's career even while being sentenced to Alcatraz.